In this contract law e-bite on supply chain distress, we explain how to spot financial distress, what contractual provisions can provide protection, and what steps you can take to help limit your exposure. What happens if you are dealing with a supplier or a customer and you become aware that they might be in financial difficulty? This could create a significant issue for you, particularly if they are a key customer or supplier. There are various sources of information that can assist you and provide indications of possible financial distress, enabling you to act promptly and take steps to limit your risk exposure. For example, you can conduct insolvency searches and financial information searches online. There might be other publicly available information which indicates financial distress. You might also have noted changes in your supplier or customer's behavior which could indicate financial distress. For example, a customer who has started paying invoices very late or only making partial payment. Contractual provisions can provide you with additional protections in the event that your counterparty is struggling financially. If you are the customer, then you would seek to include payment provisions, which mean that you only need to pay the supplier once the goods or services have actually been delivered or performed. You would also expect to see strong termination rights in the contract to enable you to exit from that contract. If you're the supplier, then your position around payment is quite different. You would seek payment to be made upfront before any goods are delivered or services provided. If that is not possible, then you would seek short payment terms and strong termination rights for non-payment. Where you are supplying goods, you might also consider including retention of title provisions. Our e-bites Plus module on supply chain distress will tell you more about retention of title rights and the impact of the Corporate Insolvency and Governance Act 2020 on retention of title and termination provisions in contracts. If one of your suppliers or customers shows signs that they are in financial distress, there are a number of practical steps that can assist. Your starting point may be to engage with your counterparty to try and understand the position they are in and the impact this could have on your business. You can then assess whether there are any finance options available and whether you need to develop or implement a contingency plan. Your legal team can help with insolvency and financial checks and contract reviews. Our e-bites Plus module on supply chain distress will tell you more about the practical steps which are available to you and will improve your understanding of the matters discussed in this introductory video. This e-bite is based on the law of England and Wales and is provided for general information only. It is not a substitute for legal advice. Please get in touch if you would like to know more or to upgrade your subscription to access WBD e-bites Plus content.